In the first set of discussion in this subject, I discussed to you about the functions of the criminal justice system as well as the responsibilities and powers of the first pillar of the CJS known as the law enforcement pillar. So as a continuation of the discussion under this course, we will be talking right now the second and the third pillars of the criminal justice system known as the prosecution pillar and the court pillar. So basically, as I have told you in the first set of discussion, there are 5 pillars of the criminal justice system. The first pillar is known as the law enforcement pillar, which is charged with the enforcement of the laws, the maintenance of peace and order, as well as on the protection of lives and properties. The prosecution and the court pillars are the additional or the other pillars under the CJS. The prosecution pillar is known as the second pillar of the CJS, while the court pillar is the third pillar of the criminal justice system. So, the discussion under this episode will only focus on the 2 pillars, again, the prosecution and the court. We will be discussing in another episode the functions under the 4th pillar, which is the correction, and the 5th pillar, which is the community. So again, ang concentration ani sa itong discussion karon will only be the second and the third pillars of the criminal justice system, specifically prosecution and court pillar. So let us discuss first the second pillar of the criminal justice system known as the prosecution. So the power or the function of the prosecution pillar is mainly to find out whether there is a probable cause to hold a person for trial. So in a previous discussion, katong sa episode 1, we defined probable cause as the set of facts or circumstances which would lead a reasonably discreet and prudent man to believe that an offense charged in the information or any offense included therein has been committed by the person sought to be arrested. So basically, ang probable cause, muna siyang mga facts sufficient to engender a well-founded belief that a crime has been committed and that the respondent is probably guilty thereof and should be held for trial. So muna yung responsibility sa prosecution pillar nga iyang lantawon if there is a probable cause naabay igong patukuranan, nabay igong rason to hold a person for trial, nabay nakaingon, posible nga nakaingon or makaingon nga kaning tawhana siya mag-commit sa krimen, so dapat siyang gi-undergo sa trial. Ang mag-determine sa probable cause is ang prosecution. Unsay purpose in the determination of the probable cause? The determination of the probable cause is the basis in putting the person into a public trial. So the National Prosecution Services is the principal prosecutor arm of the government. It is under the Department of Justice, which is primarily responsible for the investigation and prosecution of all cases involving violation of penal laws. The National Prosecution Service or the NPS was created by virtue of Presidential Decree number 1275 dated April 11, 1978. On April 8, 2010, Republic Act number 10071, otherwise known as Prosecution Service Act of 2010, was passed by Congress to amend certain provisions of the previous law, which is PD 1275. So in order to find out whether there is a probable cause to hold a person for trial, because again, the determination of the probable cause is one of the responsibilities of the prosecution pillar. Ang probable cause nga atong giisgutan under the law enforcement nga niingon nga you cannot make a warrantless arrest unless there is a probable cause. Ang purpose ato pag-determine sa police is for the arrest or to execute the arrest. So i-determine sa police kung naabay nakaingon, naabay probable cause para mag-execute siya og warrantless arrest. Pero ang sa prosecution pillar, ang pag-determine again sa probable cause, ang purpose niya is to hold a person for trial. Okay? To hold a person for trial. Now, in the determination of the probable cause, natay ginatawag og preliminary investigation. So, mao ni proseso nga dapat i-undergo in order to find out whether there is really a probable cause para ang tawo dalon sa korte para i-tried siya dito. Now, the preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and that respondent is probably guilty thereof and should be held for trial. So again, ang purpose of preliminary investigation is to find out whether there is a probable cause to hold a person for trial. When not required, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years and 2 months and 1 day without regard to fine. So take note, makandak naman ang preliminary investigation kung ang penalty that is prescribed that can be found in the revised penal code or in the criminal law is at least 4 years and 2 months and 1 day. Okay? 4 years and 2 months and 1 day at least. So kung 4 years and 2 months na siya, dili pwede siya makaver sa preliminary investigation. Kung 4 years and 2 months, kaya ang gingon diri, nga requirement is katong cases nga 4 years and 2 months and 1 day pataas. Okay? Must undergo preliminary investigation. And the preliminary investigation shall be done or shall be conducted before the filing of the complaint or information to the court. Okay? So, dapat himuon siya before sa filing sa information. The question right now is what is the difference between complaint and information? In the previous discussion, I told you or I elaborated that complaint is a written accusation subscribed by the offended party or subscribed by the complainant. Ang information is a written accusation which is subscribed or which is furnished by the prosecutor himself. So, ang nakalahi lang ani sa complaint of information is the person, is on the person who submitted or who furnished the document. So, complaint, ang ga-furnished ani, nga written accusation is the complainant or the offended party, while the information ang nag-furnished ani is ang investigating prosecutor. So, these are the stages in preliminary investigation. Muna yung mga proseso nga dapat i-undertake. Number 1, or the step 1, a complaint must be filed which shall state the address of the respondent, accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. The affidavits should be subscribed and sworn to before any prosecutor or government official authorized to administer oath or in their absence or unavailability before a notary public. So kung atong balikon, the first contact kung ang tao makommit og krimen would be the law enforcement pillar. Now, if the offended party or if the victim of the crime choose to file a complaint, ang iyang buhaton, ang iyang complaint should be submitted to the prosecution office. Okay? Iyang gisubmit dito sa prosecution office. Like in Dumaguete City, if in case the crime is punishable by at least 4 years and 2 months and 1 day, dalo nimo dito sa Hall of Justice sa Dumaguete City. Okay? Mato ka sa Hall of Justice, pangitaon nimo ang prosecution, ato dito nimo i-submit ang imong complaint together with the affidavits as well as your supporting evidences that will prove that there is a crime that is committed. So kung naa kay deposition. When I say deposition, I'm referring to the written testimony of the witnesses, mas maayo because that can be used to establish probable cause. But the affidavits should be subscribed, imong panotaryuhan sa lawyer. Or it has to be subscribed or sworn to any prosecutor or any government official. But usually, the practice right now, which is less hassle, is you go to a notary public or a lawyer capable of notarization, and then ipanotarize nimo dito ka mo subscribe or manumpa nga imong gibutan diha are the truth, or ang affidavits or ang content sa affidavits are the truth. Okay? So again, imuhang gisubmit sa prosecution ang imong complaint, imong that contains your address, imong affidavits, imong evidences, tapos make sure nga na-notarize na. Again, ang complaint is a written accusation subscribed by the complainant. So after you already submitted the documents together with your affidavits and evidences, within 10 days after the filing of the complaint, the investigating officer shall either dismiss if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant. So in step 2, di ba ang step 1 submission sa documents, in step 2, the investigating fiscal or the investigating prosecutor within 10 days will have to scrutinize, take a look on the evidences, on the documents being submitted. And if in case, after the scrutiny finds out that there is no probable cause that exists, that there is no ground to continue the investigation, automatically iyang gi-dismiss. Iyang i-move for the dismissal of the complaint. Pananglitan, gidiretso ra ka og dakop, while galakaw ka sa liplaza, padulong sa liplaza, gidiretso ra kag dakop without any probable cause or without due reason. So pag-adto sa korte, unya ni complaint ang gadakop nimo, unya yang ebidensya is lacking or ang ebidensya is not strong enough nga nakakommit ka og krimen, ang may tabuan na mingon ang judge nga oy ato i-dismiss ni ngano man walay strong ground that the crime exists. Another example is a person filed a complaint kay niingon ka nga wala ko ganahin nimo. So pagkadungog niya nga ningon ka nga wala ka ganahin niya, ni file siya complaint dito sa prosecution office. So ang investigating judge finding out that that act is just mere freedom of expression to express his feeling against a person, dili man na krimen, so automatically ang judge or ang prosecutor mayon siya nga ato ning i-dismiss ang complaint simply because the act cannot be considered as a crime. Okay? But if in case there is a strong evidence, there is a probable cause that exists upon the scrutiny of the prosecutor or the investigating fiscal, ang mahitabo is the fiscal or the prosecutor will issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant. So if in case upon scrutiny nalantaw sa judge nga naay probable cause, mahitabo is ihatag niya ang documents, ihatag niya ang copy sa complaint o ang copy sa affidavits. Asa niya gihatag? Dito sa respondent. Kinsa man ning respondent? Katong accused of the commission of the crime, katong giakusahan sa krimen. Tapos ang respondents or ang accused shall have the right to examine all the evidences. So, pwede siya makalantaw. Na siya katungod sa paglantaw o pag-check sa tanang documents na gihatag sa iyaha. So, again, step 1, musabit ka sa imong complaints, sa imong affidavits, ang imuhang mga evidences, tapos imong ipanotarize. Step 2, ang investigating fiscal or prosecutor. When I say fiscal or prosecutor, these are two terms that can be used interchangeably. Pareha lang na. Step 2 again, the prosecutor within 10 days will have to take a look at it And then when he finds out that there is no ground to continue with the inquiry, he will dismiss the complaint. But if in case there is a probable cause or there is a strong ground that exists to continue with the inquiry, what he will do is to issue a subpoena to the respondent, attaching thereto the copies of the complaint and all the affidavits. Tapos, ang respondent will have the right to examine. Now, ang step 3, within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavit and that of his witnesses and other supporting documents relied upon for his defense. The counter affidavit shall be subscribed and sworn to and certified with copies thereof furnished by him to the complainant. So basically, ang step 3, tagaan ka og pulo ka adlaw, di ba gi-examine naman nimo ang complaint ug affidavits gikan sa complainant. Karon gitagaan kag pulo ka adlaw upon receipt, meaning gikan sa pag-receive, pagdawat nimo, tagaan kag pulo ka adlaw to file your counter affidavit. So unsa man ni counter affidavit? So imong gi-deny ang claim nga naa sa complaint. So kung ningon dito sa complaint nga ikaw mo'y gakawat sa ako nga kwarta. So dapat sa counter affidavit mo nakabutan dito nga these are the mo na ako ang evidence to prove nga wala ko gakawat. Okay, kay counter affidavit man. Ang counter affidavit dapat po notarized by a lawyer. Pila ka adlaw ang gihatag? 10 days. So make sure once you receive the subpoena along with the copy of the complaint, dapat kuha po kang imong kaugalingong ebidensya to prove your claim. Okay? Tapos kuha po kag witnesses or na po kay affidavits from your witnesses and then ipanotarize nimo na imo nang gisubmit dito sa prosecution. Tapos ang imo nga gisubmit dito sa prosecution, tagaan po copy ang complainant. If the respondent cannot be subpoenaed or if subpoena does not submit counter affidavits within the 10-day period, the investigating officer shall resolve the complaint based on the evidence presented by the complainant. So basically, if in case the person cannot be subpoenaed, like di ko siya makitaan, or just reject the call coming from the prosecution for the submission of his counter affidavits, then what will happen is the investigating fiscal or prosecutor shall resolve the complaint in favor, of course, to the complainant. Nganong in favor man sa complainant? Considering nga ang resolution sa complaint will only based on the evidences presented by one party and that party is only the complainant. Now, if the investigating officer may set a hearing if there are facts and issues to be clarified from a party or a witness, the parties can be present at the hearing but without the right to examine or cross-examine. The hearing shall be held within 10 days from submission of the counter affidavit. So, meaning, if nakapasa or nipasa ang accused sa iyang counter affidavit together sa iyang evidences, pwede mo patawag ang investigating fiscal or prosecutor in order to clarify some issues. Usually, ang kaning step 5, mao po na panahon nga mangita ang prosecutor or ang investigating fiscal of an opportunity for an amicable settlement within the two. Kaya basit pwede pa. Kaya kung pwede ma-settle sa prosecution, much better in order not to overwhelm the workload of the court pillar. So kung nagkasinabot sa prosecution, mas maayo pagpatawag. Okay? But again, in step 5, the main purpose is on the clarification. Okay? Clarification area only. Pero kung magkasinabot sa step 5, pagkatubang nila, paghangyo sa fiscal, din mas maayo. Number 6, which is the last step, within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. So, ang step 6, after 10 days, gikan sa pag-hearing, pagpakita sa complainant o accused sa opisina sa prosecutor, ihap kag pulo ka adlaw, tapos imo nang tagag decision whether there is sufficient ground or whether there is no probable cause to hold a person for trial. Now, what happens if there is no probable cause? What will happen if the investigating prosecutor will move or will decide that there is no probable cause? So kung wala probable cause upon the determination of the prosecutor, then what will happen is the complaint will be dismissed. Okay? So kung ni-submit og counter affidavit ang accused, tapos nalantawan sa prosecutor nga justifiable ang iyang mga evidences or convincing ang iyang evidences, what will happen is wala may probable cause, so i-dismiss ang complaint. But if there is a probable cause, what will happen is the prosecutor or the investigating prosecutor shall prepare the resolution and information. He shall certify under oath in the information that there is reasonable ground to believe that a crime has been committed. So, unsa man ang information? Again, ang information is the same with the complaint. Ang nakailay lang kay ang complaint is furnished by the complainant, while information is furnished by the prosecutor. Pero kaning duha puro ni mga written accusation. Okay? Ang complaint ug information. Ang ga-furnish sa complaint, again, complainant. Ang ga-furnish sa information, ang prosecutor. So within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor. These shall act on the resolution within 10 days. So meaning, once there is a probable cause, issue kag resolution nga naay or information nga mingon kadto nga naay probable cause. Tapos imo nang isubmit dito sa provincial prosecutor or city prosecutor or the chief state prosecutor. Usa lang ani ha? Pwede provincial prosecutor, pwede city prosecutor, pwede chief state prosecutor. Tapos ang imong gitagaan shall act on the resolution within 10 days, whether to disapprove or de-approve the resolution. No complaint or information may be filed or dismissed by the investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor. So as I have stated a while ago, the purpose of forwarding the resolution or the information to the city prosecutor or the chief state prosecutor or the provincial prosecutor is for the approval. Where the investigating prosecutor recommends the dismissal of the complaint, but his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or the ombudsman on the ground that a probable cause exists, the latter by himself file the information against the respondent or direct any other assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. So meaning, whether dismissed ang complaint, di ba, after 10 days, imo mang lantawon o lantawon sa prosecutor kung nabay probable cause. Kung wala probable cause, i-dismiss. But still, you have to file a resolution stating the reasons, stating the facts for the dismissal of the complaint. Pero pag submit mo sa resolution dito, even though niyo kang i-dismiss na nga complaint, pero gi-disapprove sa provincial or city prosecutor ang imo nga resolution because they believe that there is a probable cause that exists, what will happen is ang chief state prosecutor, ang city prosecutor, sila nay mo file sa information, dili na ikaw. Sila nay mo file sa information against the respondent. Or, pwede po nilang ilang orderan ang assistant prosecutor or state prosecutor to file the information on their behalf without conducting another preliminary investigation. So, akong Osbon, once move ka for the dismissal, tapos pag submit mo sa resolution nga ipa-dismiss nimo ang complaint, gi-disapprove sa provincial or sa city prosecutor, ang may tabo mo file ang provincial or city prosecutor sa information against the respondent because they believe that there is a probable cause exist. So nabali ang imong decision. Or pwede silang musugo og another prosecutor to file the information. If in case ang nakabutan sa imong resolution is there is a probable cause that exists pero gibali siya sa provincial or city prosecutor, ningon ang provincial or city prosecutor nga, oy, wala may probable cause ani nganong niingon makang may probable cause nga wala man ang matuman walay lain kundi ang provincial or city prosecutor or chief state prosecutor nga imuhang gipasahan sa imong resolution. So those are the steps in the conduct of the preliminary investigation. So atong balik ko na ang step 1. Kung ang tawo or ang offended party ganahang mo file og kaso. Okay? Di ba ito ibutang nga naka-blatter na sa law enforcement pillar. Di mingon ang pulis nga unsa man mukiha ka. So kung mukiha, sige, pwedeng fotokopihan ang blatter tapos mag-draft ang complainant o ginatawag og complaint affidavit. Or moadto siya sa lawyer para ma-draft ang complaint affidavit. Dapat na kay complaint affidavit, imong affidavit sa imong witnesses or deposition o uban pang documents such as evidences. Asa nimo na gisubmit? Gisubmit nimo dito sa prosecution office or sa prosecutor. Pag-receive sa prosecutor within 10 days, iyang lantawon if there is a ground for the continuation of the investigation. So kung walay basihanan ang complaint, i-dismiss niya. Okay? Walaon, i-dismiss ang kanang nga complaint kay walay basihanan. Pero kung nay basihanan or nay rason nga ang krimen posible nga nahitabo by this committed by this person, ang iyang buhaton is mo issue siya og unsa man supina. Asa ang supina gi-issue? Dito sa respondent. Kisa gani ang respondent munig katong accused. So unsa may nakabutan sa supina? Ang supina na naka-attach nga copy sa complaint o sa mga affidavits gikan sa complainant. Tapos ihatag mo na sa respondent or sa accused. Ang accused kinahanglan mo file siya og counter affidavit together with his evidences. Tapos pag-file niya, posible nga gipatawag sila sa prosecutor for clarificatory reasons. Then after ana, humagpatawag, ang mahitabo mo decide after 10 days ang prosecutor if there is a probable cause that exists or there is no probable cause that exists on the case at hand. Tapos, kung naay probable cause, mahitabo, issue siya resolution. Pag issue niya resolution, asa niya gihatag? Dito sa state prosecutor or provincial prosecutor. Kung balihon ang iyang decision sa provincial city prosecutor or sa chief state prosecutor, ang matuman katong naa sa taas. So pwedeng mo file ang provincial or city prosecutor og information without conducting another preliminary investigation. If the investigating fiscal will move for the dismissal of the case, still mo file siya og resolution. I-state dito ang mga facts or circumstances ngano yang gi-dismiss ang case. Asa i-submit again ang resolution, same lang gihapon. Kung balihon gyapon ang iyang decision, kay mo believe ang provincial or city prosecutor nga nay probable cause nga na-exist, ang mahitabo is mo file og information ang katong naa sa taas, ang provincial or city prosecutor without conducting another preliminary investigation. Okay? So if in case approved na tibuta nga the information has already been approved or the resolution has been approved by the city prosecutor or provincial prosecutor that a probable cause exists, what will happen is ang information nga gikan sa prosecution ipasa na dito sa korte. Okay? So, adto na sa court. So, unsa naman ang court? Ang court mao na ni katong third pillar of the criminal justice system. So, meaning, asa ganig issue ang information? Ang information gi-issued gikan sa prosecution. Tapos asa ipasa? Ipasa niya dito sa court. Unsa ang court? Ang third pillar. Alright? So, pag abot sa court, na po'y ginatawag dito o investigating judge. So, unsa man yung function sa investigating judge? The investigating judge will have to find out again, determine again if there is a probable cause that exists in the information. Okay? Kay kung naay probable cause, mingon ang judge nga, oy, tinuod jud ay nga naay probable cause. Na may probable cause to hold a person for trial, ang iyang buhaton mo issue siya ginatawag og warrant of arrest. Okay? Kung sa mga warrant of arrest, again, based on the previous discussion, this is an order coming from the judge ordering a police officer to arrest the person named in the warrant. Okay? So, dakpon, kailangan na may warrant of arrest. Pero kung ang tao, again, based on the previous discussion, kung ang tao na nasa sulod sa prisuhan, tapos na probable cause paglantaw sa judge sa information, ang judge dili mo issue og warrant of arrest kung dili ang iyang issue is commitment order. Nganong commitment order? Kay naa naman mismo ang accused sa prisuhan. Okay? So meaning, there are two pillars in the criminal justice system as far as the determination of the probable cause to hold a person for trial. Duha ka pillars. Una, ang prosecution mo determine sa probable cause to hold a person for trial, same as the court. Okay? So again, pagpasa sa information, lantawon sa judge kung naabay probable cause again, tapos kung walay probable cause, i-dismiss niya. Okay? I-dismiss ang information. Pero kung naay probable cause, mo issue siya og warrant of arrest. Pero kung ang tao is already inside the jail, ang iyang issue is kinatawag og commitment order. I hope nasabtan ning area. So, let us go now to the third pillar. Now, the court is a body to which the administration of justice is delegated. Courts are judicial tribunals officially assembled under authority of law at the appropriate time and place for the administration of justice, through which the government enforces its sovereign rights and powers. The court is where the administration of justice is entrusted to. It is also the court that will determine whether the person is guilty or innocent of the offense charged against him. There are no other pillars of the criminal justice system that will determine the guilt of the person other than the court alone. Okay? Korte lang ang naikatungod or naikagahom sa pag-determine kung guilty ba or innocent ba ang tao sa accusation. Wala na ilain. Dili makadetermine ang law enforcement, dili makadetermine ang prosecution, dili makadetermine ang correction, di po makadetermine ang community. Ang makadetermine sa guilt sa person or innocence of the person is the court and the court alone. The judge is a public officer so named in his commission and appointed to preside over and to administer the law in the court of justice. So the presiding officer is known as the judge. Judicial independence is the freedom of the court to settle legal controversies or disputes with an impartial eye and an even hand and bowing to no one except the law. It is the freedom of the judges to perform their functions without interferences from the executive or the legislative branch of the government. In the first set of discussion, ningon ko dito nga natay three independent bodies of the government or three branches of the government: the executive, the legislative, and the judiciary. So kani sila autonomous man ni, when I say autonomous, independent man ni with each other. Ang court na belong sa judiciary. Ang legislative mo Senate of Congress. Ang executive mo ni katong president himself. So na sila independence, na sila katungod. Because the judiciary is separated from the other two branches of the government. So their decision should be without the interference or influence from the executive or the legislative branch of the government. That is why, kung makita ka sa Lady Justice, imong makita nga naka-blindfolded siya. Naka-blindfolded, that will signify nga dapat na impartiality or fairness in the administration of justice. Gadala siya timbangan simply because ang timbangan would signify impartiality. Okay? Impartiality or fairness. Judicial review is the power of the courts, ultimately the Supreme Court, to interpret the Constitution and to declare any legislative or executive act invalid because it is conflict with the fundamental law. So again, when we say judicial review, this is the power of the Supreme Court to declare that a particular law is unconstitutional. Okay? Munang makita nimo karon recently, daghang ni file og resolution to the Supreme Court nga innullify ang Anti-Terrorism Act sa Pilipinas, because they believe ang Anti-Terrorism Act in the Philippines is something that will be used to exploit the weaknesses of the poor individuals. So pwede nga pasakag resolution sa Supreme Court, latawon sa Supreme Court kung unconstitutional ba or constitutional ba ka na nga balaod. Now, let us go now to the organization of courts according to the Batas Pambansa bilang 129. The courts are organized, under this law, the courts are organized into three main clusters. Una is regular courts, ikaduha, special courts, ikatulo is quasi-judicial agencies. Now, let us discuss first the first cluster, which is regular courts. The regular courts consist of the lowest to the highest tribunal. The lowest would be the Metropolitan Trial Court, Municipal Trial Court, and Municipal Circuit Trial Court. So, unsa may ilang jurisdiction? Jurisdiction nila is to settle cases, to tried cases, which are in violations of the city or municipal ordinances. Okay, muna ilang jurisdiction. They also have exclusive jurisdiction over all offenses punishable with imprisonment not exceeding 6 years irrespective of the amount or fine. Okay? So, muna jurisdiction. The question right now is, sa may nakalahian ng tulo? Metropolitan, Municipal, o Municipal Circuit Trial Court. Metropolitan Trial Court muna katong dagko nga mga syudad like Metro Cebu, Metro Manila, nanay Metropolitan Trial Court. Municipal Trial Court meaning sa isa ka munisipyo na ay usa ka korte. Kung duha ka munisipyo ang gi-covered sa usa ka korte, ang tawag na Municipal Circuit Trial Court. Let us say for example, Municipality of Shaton and the Municipality of Zamboanga. Tapos naay usa ka korte nga ga-cover sa duha ka municipalities, ang tawag na is Municipal Circuit Trial Court. Pero kung usa ka korte, ayan jurisdiction, usa ka municipality, ang tawag is Municipal Trial Court. I hope I am understood under this area. Ang taas sa Metropolitan Trial Court, MTC o MCTC, ang ginatawag og Regional Trial Court or the RTC. It shall exercise exclusive jurisdiction in all criminal cases not within the exclusive jurisdiction of any court, tribunal, or body except those now falling under the exclusive and concurrent jurisdiction of the Sandigan Bayan, which shall hereafter be exclusively taken cognizance by the latter. Also, regional trial courts shall exercise appellate jurisdiction over all cases decided by the MTC, Municipal Trial Court, Municipal Circuit Trial Court, and the respective territorial jurisdiction. Sa maling appellate jurisdiction, kung ang accused is found guilty in the MTC or the MCTC, pwede siyang mo-appeal. Kaya katungod man niya, meaning, mo-appealar siya dito sa taas nga korte, asaman, sa Regional Trial Court. Okay? Ato dito siya mo-appeal. The next one is the Court of Appeal. So, if we will arrange this one into a ladderized order, you go back to the bottom portion of the hierarchy. And in the bottom portion of the hierarchy, you can find the Municipal Trial Court, the Municipal Circuit Trial Court, and the Metropolitan Trial Court. Above the bottom portion would be the Regional Trial Court. Tapos above sa Regional Trial Court, ang ginatawag na to Court of Appeals. Now, it has jurisdiction to issue writ of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and auxiliary writs or processes whether or not in aid of its appellate jurisdiction. Also, it has exclusive jurisdiction over actions for annulment of judgment of regional trial courts, and exclusive appellate jurisdiction over all final judgments, resolutions, orders, or awards of regional trial courts and quasi-judicial agencies, instrumentalities, boards, or commissions, etc. So, buot ipasabot, ang Court of Appeals, iya is, from the word appeal, kung ang tao is guilty sa Regional Trial Court, pwede siyang mo-appealar sa taas nga korte. Asa man nga korte? Court of Appeals. At the same time, the issuance of the mandamus, prohibition, certiorari, writ of habeas corpus, quo warranto, and other judicial documents adto na dito sa Court of Appeals. Ang pinakataas or ang mas taas sa tanan nga korte ang ginatawag nato og the Supreme Court. Okay? The Supreme Court pwede siya maka-decide og tanan nga mga apilar katong ni appeal. Okay? Kung guilty Japon sa Court of Appeals, pwede Japon nga mo-appeal dito sa pinakataas ang Supreme Court. So, ang jurisdiction niya not just on the appeal side of the judiciary, pwede po siya nga mo handle of cases affecting ambassadors, public ministers and consuls, as well as the petitions for the issuance of writs of certiorari, prohibition, and mandamus against the Court of Appeals. The Supreme Court shall have exclusive jurisdiction to review, revise, reverse, modify, or affirm on appeal as the law or rules of court may provide, final judgment and decrees of inferior courts as herein provided. So whatever decision sa lower courts, gikan sa Supreme Court, pwede niya nga ma-reverse. Okay. So again, mao to yung mga korte under sa regular courts. Again, itong balikon, ang Metropolitan Trial Court, Municipal Circuit Trial Court o Municipal Trial Court. Above ana is ang Regional Trial Court, the Court of Appeals, the Supreme Court. Those are the courts under the first cluster. Sa second cluster, we have the special courts, which consist of three. The Court of Tax Appeals, which jurisdiction is about taxes, like tax evasions. The Sandigan Bayan, which jurisdiction involves corruption of government officials. The Sharia courts, which have limited jurisdiction over cases relating to Muslims. So kung ang krimen kabahin or ni-violate sa Sharia law, which is the principles or the laws of the Muslims, so pwedeng ato sa Sharia court. Ang Sandigan Bayan katong mga kaso nga ga-involve og mga public officials nga ilang involvement sa krimen are those crimes or are those cases related to the performance of their duties as a public employee. So corruption cases, grave misconduct, or let us say abuse of authority ato ni dito sa Sandigan Bayan. Ang last nga cluster of the court is known as the quasi-judicial agencies. So unlike regular and special courts, quasi-judicial bodies do not possess judicial power. Instead, they possess and in fact exercise what are termed as quasi-judicial power. Even though they are not court of justice, either the Constitution or the special statutes empower these agencies to exercise such quasi-judicial power solely in aid of the administrative power that the administrative agency is allowed only for the empowered to exercise. Ang examples ani are the following. We have the National Labor Relations Commission, which jurisdiction is about labor cases, Civil Service Commission, Commission on Elections, and Commission on Audit. So ang ilang mga kasong handulan dapat relative sa ilang nature of office. So kung kabayan sa election or violation sa election code, ato kas COMELEC. Kung violation of the Civil Service Commission Act, then ato ka dito sa civil service. Kung violation about transparency on the expenditures or public expenditures, ato ka sa Commission on Audit. Also, the law provides the maximum periods in rendering decisions. Okay? So, there is a specific reglementary period provided by the law which will consider the specific duration or the specific span of time where a specific type of case should be solved. For the Supreme Court, itagaan siya 24 months, right? 24 months to solve or to render decision. For the Court of Appeals and other collegiate appellate courts, within 12 months unless reduced by the Supreme Court. For the lower courts na ay 3 months ang gihatag to solve a case. Pero we have to take note again, we have to consider the overwhelming workload within the courts in the Philippines. Since daghan man kayong kaso that are lodged in the courts in the Philippines, pwede nga mo exceed, okay? With justifiable reason, pwede nga mo exceed on the reglementary period. Say for example, in the case of the Ampatawan massacre, it took a lot of years para ma-solve ang case. So wala na consider ang reglementary period. The question is, na by violation sa speedy trial? Ang tubag is, wala. Simply because we have to consider, number one, the evidence is presented. Number two, the load that is prevalent in various courts in the Philippines. So those are the discussions under this episode. We discuss only the two pillars of the criminal justice system, the second pillar which is the prosecution, and the last pillar is the court.